Okay, welcome everybody. The purpose of this class is to prepare you, to give you some pointers for the forthcoming examination. It is not a revision class. The purpose is not to go through the work again. By now you should all have practically completed your preparation for the forthcoming examination, just tying up loose ends, starting to do some revision exercises, etc., etc. So the purpose of this class, which should not take too long, is essentially to, as I said, give you some pointers and also point out some common mistakes that students regularly make that I want to warn you against. So let me just share a screen. Okay, so first of all, we have already circulated the exam layout. So I'm not going to go through that again. Starts off with multiple choice. There is a multiple choice practice quiz on e-learning. Please feel free to do that as many times as you want. You have an indefinite number of opportunities to do it. Do it as much as you like. We have seen in previous assessments that you really do benefit from going through the multiple choice. Remember, multiple choice is 40 of the 100 marks. That's nearly 50%. If you do well in your multiple choice, chances are that you will pass the exam. If you do poorly in the multiple choice, however, you have to do very, very well in the other questions to make up for it, which is not always that easy. Question 2 then is short knowledge-based questions. Study, study, study. That's literally what it is. Knowledge-based questions. No application required. Please watch your mark allocation. If it's a 3-mark question, you should be able to answer it in 3 lines. 4 marks, 4 lines. That's a rule of thumb. If it's a 3-mark question and you find yourself writing half a page, chances are you've got the wrong answer. You should not need half a page to answer a 3-mark question. The rest of the questions then are all case study, application questions. First thing to note, if a question consists of 2 separate questions, sub-questions, please read both the questions before you start answering. Often they are related to each other. If they're not related at all, I would have made them 2 separate questions, not 2 sub-questions. So they're related to each other. Read both and think carefully, what am I asking in each question? So that in, say, question 3.1, for example, you don't end up writing everything you could possibly think of and come to question 3.2, you've run out of things to say, and then you start writing nonsense. Also, and this is a general problem, a mistake that students make. When it comes to reading the question, sorry, firstly, you never make up your own facts. I give you the facts. I give you everything you need to know. You don't have to imagine anything. I write the stories. You write the answers. Secondly, what is the question? What do I really want to know here? That is quite important. Students often make a mistake that they think they know what I'm asking and they answer something that I haven't asked. Also, specifically perhaps with regard to question 2, your knowledge-based questions as well. Your question verbs. List, describe, explain, compare, etc., etc. If I'm asking you to list something, I literally want you to list it and no discussion is required. I'll give you an example of that when it comes to auditors, when we talk about auditors later. A description obviously requires more detail and explanation. Similarly, there's another one here. A discussion will often include your own opinion, and if you compare, this one is important. I'm asking you to compare. You need to list the similarities and the differences. However, if I'm asking you, I don't know why this is underlining now. What is the difference between whatever? I'm literally looking for the difference. What are the differences? This does not mean I'm not looking for two definitions. Asking you what is the difference between A and B, and you give me a definition or an explanation of A and an explanation of B. That is the wrong answer. If I'm asking you what is the difference, I want you to point out the differences. You can either do this in tabular form or not. Let's give you an example. I'm going to do this in tabular form. Let's say the question is, what is the difference between redemption of preference shares and buyback of shares in terms of section, what is it, section 89. I think it's 89, could be 98. If I'm wrong there, just forgive me. So what is the difference between these two concepts? So you've got redemption and you've got buyback. So I don't want you to tell me what is the redemption of preference shares. Also, don't want you to explain the rather elaborate procedure for buying back of shares. We'll get to that later in this class as well. But I don't want you to, this question is not asking you about the procedure to be followed when a company wants to buy back its own shares. It wants to know what is the difference between these two statutory provisions. So the first difference, redemption of preference shares. Only preference shares can be redeemed. Buyback of shares, any type of shares can be bought back. Another difference between buying back of preference shares and redemption of redemption of preference shares and buying back of shares is, when can the company do this? Redemption is normally the time indicated they're normally redeemed at a fixed time. So when you buy these redeemable preference shares, you know that in 2 years' time, they will be redeemed. Buying back of shares, anytime when the company deems it necessary. Redemption of preference shares, you can insist on them being redeemed, because when you bought them, that you bought them knowing that they will be redeemed at a specific time. Buying back of shares, as shareholder, you have no right to insist at any time that the company will now buy back these shares from you. It doesn't happen this way. More important difference, redemption of preference shares. Only paid from income. The issue of fresh shares, sorry, typo. Or profits available for dividends. Buying back of shares, no limitation. Company can even go to the bank and borrow money if it has to. Well, not really, but can come from any source of money. And then redemption of preference shares. Because of that provision, that it can only be paid from income earned through the issue of fresh shares or the profits available for dividends, it does not result in remember, this is the concept of capital maintenance. The common law rules that company must maintain its capital. Even before those common law rules were changed in the 2004 legislation, the Companies Act already provided for redemption of preference shares, because redemption of preference shares does not reduce the share capital of the company. Buying back of shares, shares that are bought back are cancelled and become authorized but unissued shares. So that is the difference. I don't want to know about special resolutions and solvency and liquidity and all of that. I want to know what is the difference between these two procedures. If you tell me, give me a description of the one and a long description of the other one, you will not be getting any marks. But speaking of that, let's look at this procedure, the buying back of shares. In terms of common law, the common law rules on capital maintenance, a company was not allowed to buy back its own shares. This provision has, however, been changed in the Companies Act of 2004. All of this is discussed in Unit 14. Unit 14, capital maintenance is important. So let's look at the buying back of shares. The Companies Act does provide in quite detail, it's an extensive detailed procedure that a company needs to follow when it is buying back its own shares. And when we did this particular unit, when we discussed that particular section, let me just check quickly what section this is. 89. I said up there, I said it's 98. My bad. Oh, no, I was correct. It is 89. So section 89. Now, when we did section 89, I pointed out to you that you should refrain from just memorizing this whole thing, because you can potentially lose marks if you don't relate your answer to the case study. What do I mean by that? Ask yourself, why does the company want back these shares? Now, this is preparation that you're doing in your mind. This isn't part of your answer. You're not writing this down, but you need to clarify this in your mind before you start answering. Why does the company want to buy back these shares? Whose shares are they buying? Is it any shareholder? So not a specific shareholder, any shareholder, because they want to reduce the share capital, various reasons why companies can do that. For example, to increase the dividend potential of other shares. Let's say they've got Class A shares and Class B shares, but they want to reduce the number or completely buy back all the Class B shares. That means that the holders of the Class A shares will end up getting, having the chance of earning more dividends. In that case, this isn't Johnny and Peter and Susie's shares that they buy. It's anybody who owns that particular class. So it's not specific. But sometimes situations can arise that a specific shareholder wishes to sell their shares back because they want to leave the company, they want to move on with their life. If it's the case of a specific shareholder, I can tell you now, this will only happen in a private company that only has a number of shareholders. So there are 3 shareholders or 4, and one of them wants to move out of the company, start doing something else, and wishes to sell their shares back to the company, because the company and the other shareholders don't actually want these shares to go to an outsider. But in a private company, obviously, your individual shareholders are not known by name. So will not happen in practice that there will be a specific buyback in a private company. Which brings us to the next question you have to clarify in your mind. What type of company is this? Is it a private company or a public company? Note the name of the company. So that's your preparatory work that you do in your mind before you start answering the question. You're not going to get any marks for this. Just want to put this in here. So you've clarified those thoughts in your mind. Now you start answering your question by describing the procedure, the requirements that have to be followed. So the first requirement is that a buyback the articles of the company must permit a buyback of these, must allow a company to buy back its own shares. Remember, before 2004, this would have been illegal. So articles of companies that were registered before 2004 will definitely not authorize the company to buy back its own shares, because it would literally have been illegal. If the articles does not permit the buyback of shares, you need to amend the articles. By way of a special resolution. Special resolution is always required for any changes of the constitution of a company. Referring specifically to the articles here, if you're getting confused, remember, if in doubt, leave it out. If you say it must be authorized in the constitution of the company, you will absolutely get your marks as well. So the company must then first adopt a special resolution to amend the articles, if it's necessary. Once that has been done, in fact, for practical reasons, but this isn't in the notes, I'm just telling you, that they don't have to have 2 meetings. Both these procedures can be done at the same meeting of shareholders. So they can first adopt a special resolution to amend the articles, and then they need to adopt a special resolution to approve the transaction. So we're talking of 2 special resolutions here. Can be at the same meeting, but these are 2 separate resolutions. Now the Companies Act, when it refers to the special resolution to approve the transaction, The Companies Act says it can either be a general approval, which is valid until the next AGM, or it can be a specific approval. Let me just check here. Yes, this is specific. I just want to check my terminology. Or it can be a specific approval, which is valid for a specified period of time, for a particular And here I come to my point that you must be specific. Because if you're going to be writing, it can be a general approval valid until the next AGM or a specific approval for a particular acquisition, you are not going to be getting marks. Why not? Because you've asked yourself in your brain, whose shares are they buying? If they want to buy back 50% of the Class B shares, it will be a general approval. If they want to buy back Johnny's shares, it will be a specific approval. So don't tell me it can be either. Tell me which one it is. After the special resolution has been adopted, it provides that the company must send an offering circular, which is not required is listed on a stock exchange, or if the special resolution that it is not required. Once again, I don't want you writing, the company must send an offering circular. The offering circular is not required if the company is listed on a stock exchange or if the special resolution provides that it is not required. Tailor make your answer. If this was a specific approval, then your answer would rather be that, let's write this down for you. It was a specific approval not answering offering. That it will not be required. An offering circular, think about this. The offering circular, that's like a letter, an offer being sent to all the shareholders of that particular class that is affected to make sure that they all have the opportunity to participate in this offer if they want to. But if it's just Johnny's shares that are being bought back, they don't have to send an offer to Susie and Peter and whoever else. So in that instance, the need for an offering circular will be excluded in the special resolution. What type of company is this? If it's a private company, don't tell me that it's not necessary or is not required if the company is listed on the stock exchange, because it won't be. I will give you the information whether it is listed or not. So specifically then for these two aspects, I need you to be specific in your answers. The rest of the procedure is the same. That doesn't matter what type of acquisition it is. Okay, my bullet points aren't working here. Never mind. What is their further procedures? The company must be liquid. Company must be solvent. Shares that are bought back. I'm not going to continue typing all of this out here. This procedure is in the notes in Unit 14. So I'm not going to spend time now typing out the whole thing. I just wanted to specifically do that first bit. So remember, that isn't a complete answer. The answer is in the study guide. So you can go back and look at the rest of the procedure there. I wanted just to illustrate that you must be specific in your answer. If I ask you in the exam, what is the difference between the redemption of preference shares and buying back of shares in terms of Section 89? This is not what I'm looking for. That will not earn you any marks for that particular question. If I'm asking for the difference, I want the differences. Okay. Moving on then. So the unit on capital maintenance, Unit 14, is important. Make sure you've gone through Unit 14 with quite some concentration. That brings us then to Unit 15, auditors. Given that you are all studying towards a Bachelor of Accounting, obviously the unit on auditors is always important. Some things to make sure you know there. Firstly is who may be auditors, who may be appointed as auditors. Secondly, the procedures for the removal of auditors. There are two procedures, two possible procedures, depending on how the auditors were appointed. If the auditors were appointed by the directors because there was a casual vacancy in the position of auditor, they can be removed at any general meeting. It requires 28 days notice, special notice, but they can be removed by way of an ordinary resolution. If, however, if they were appointed by the shareholders at an annual general meeting, they can similarly only be removed at an annual general meeting. It still requires 28 days notice. Normally the notice period for an AGM is 21 days. If one of the agenda points is the removal of the external auditors, or the directors, then 28 days special notice is required. In this instance also, we need a special resolution. So, appointed by the directors, any general meeting, any time of the year, special notice, ordinary resolution. They were appointed at the annual general meeting. They can only be removed at an annual general meeting, 28 days notice, and a special resolution. The next aspect of auditors, which is important, is the civil liability. Civil liability of the auditors. Civil liability of the auditors, once again, you need to decide oh, sorry, why is my auditors? Who wants to hold the auditors liable? Is this the company itself? Or a third party? Why do you need to decide this before you start answering? Of course, once again, this is one of those questions that you ask yourself in your mind before you start answering. Not going to get marks for this, but it's going to determine the content of your answer. If it's the company itself, they have two possible legal grounds, either breach of contract or the law of delict. If it's a third party, they can only make use of the law of delict. The law of delict in both instances is the same. Doesn't matter, the law of delict stays the same, whether it's the company or a third party. So the only difference it makes is if it's the company itself, you're not going to be referring to breach of contract. If it's a third party, you're not going to be referring to breach of contract. You're only going to be referring to delict. If it's the company itself, you need to refer to both. Law of delict has got 5 requirements. There must be an act, also known as conduct. There must be wrongfulness. Wrongfulness is the act wrongful. Wrongfulness describes the act. An act will be wrongful if it breaches a substantive right that the plaintiff has. So the wrongfulness describes the act. Then there must be fault. Remember, wrongfulness is a legal term. It doesn't mean he was wrong or the answer was wrong. Fault, similarly, it describes the external auditors. The external auditor's state of mind. Was this intentional? Was he negligent? So wrongfulness, and fault doesn't mean mistake. Fault is a legal term. Don't tell me he made a fault. He was negligent. The element of fault has been met. Damages, you need to prove, they need to prove the amount of damages. And causation. Did this wrongful, negligent act cause the damage? Is there a connection? Would they have suffered the damages if it had not been for this wrongful act, this wrongful, negligent act? In order to succeed in a claim based on the law of delict, you have to prove all 5 those requirements. Read your questions carefully. Warned you there. Read your questions carefully. What am I asking in this question? Am I asking you, will they succeed? Am I asking you, what must they prove? Or am I simply asking you to list the elements that they must prove? If I'm asking you to just list the elements that they must prove, you must literally just do that. You don't have to refer to any facts. If I'm asking you, will they succeed, or what must they prove, or something like that, you need to give me more detail and also refer to the relevant facts. So read your questions carefully. Okay, big hairy monster. Unit 8. That you are all still battling with. You'll be getting the handout. The handout is attached to the exam. So you don't need to memorize any of the details contained in those sections of the Companies Act. I have, however, and this was very strange, when I marked the special test. This is the first time that I've picked this up from students. I've never seen it before, because the questions on Unit 8 typically say that you must motivate all your answers. And suddenly I found that students were copying long sentences from the handout as motivation. More often than not, like just really random sentences, and sometimes just literally not even the whole paragraph, just stopping in the middle of the paragraph, in the middle of the sentence. Your motivation is not going to come out of the handout. You will not. If I wanted you to copy out of the handout, I would have said, copy section 188 into your answer script, or copy section 207 into your answer sheet. You're not getting any marks for your ability to copy something from one piece of paper onto the other piece of paper. Your motivation consists of the reasons and the calculations, if it is something that you needed to calculate. Always show your calculations. Show your calculations as part of your answer. So don't, when you get to this particular question, start doing half a page of calculations, and then suddenly, and then you start answering, because I'm just going to draw a line through those calculations. If they're not part of your answers, calculation must be, I don't want to, if you've answered a question, go and scratch somewhere to find the answer. You must give, to find your calculations or whatever. Your calculations are part of your motivation. I want to see them. So, standard question here, issued share capital consists of blah, 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 blah. That's the shareholding. If you were to add all of them up, you would see that in this particular case, the shareholding, or if you add together all the Class A shares, it equals 50. All the Class B shares, it equals 50. All the Class C shares equals 50. In this particular question, it does. It is not always the case. But don't stress about that. Read your questions. That will become relevant when you get to your questions. So you don't have to now start making these calculations because you haven't started answering your question yet. Important to note there that Class C are preference shares, so they are preference shares in this company. And now I've told you all dividends payable to the preference shareholders have been fully paid to date. Why is this important? Why is this important? Do the have voting rights? Do the preference shareholders have voting rights? That could affect some of your answers. When do preference shareholders have voting rights? Content of the resolution. Does it affect their class rights? And also, have their dividends? Are their dividends up to date? There, I've told you all dividends have been fully paid up to date. Can't, at this stage of reading through the question, answer the first question because we haven't got to what are they voting about yet. So Annie, Benjamin, and Carol are the directors. They intend selling fixed property at a price which will be detrimental to the company and will drastically reduce the value of their shares. And they feel that a general meeting should be called. Okay, so now you've read this carefully. Calculate the value of the total issued shares of the company. Now, before you start answering these questions, okay, I've copied and pasted the answers there to save a little bit of time. So you've got 3 questions. Now, before you start answering people, read every single one of these questions. Answer only what I've asked. So calculate the value of the total issued share capital of the company. As simple as that. there we have the issued share capital. You've got your calculators, you're doing the maths. $50 Class A at $10 each gives you $500. So to make my own life easier for myself here and get my calculator out. So we've got 50 times 15 gives you 750. 50 times 200 gives us what was our answer there? 10,000. And then your total, add them all together. So that's 10,000 plus 750 plus 500 gives us 11,250. That is your motivation. That is your motivation. I want to see that calculation as part, how you've calculated, as part of your answer. Okay, can George and Harry call a meeting in terms of section 188? We had the same question in test 1, not the same, well, similar question. Can they call a meeting in terms of section 188? In the special test, I gave a similar question, but I referred to section 189. You've got the handout in front of you, people. Read the correct section. There were so many students in the special test that referred to the requirements of section 189, 188 when I asked for 189. Obviously got their answer wrong. What are the requirements for section 188? There are 2 requirements. There must be 2 or more shareholders with a minimum of 5% of the issued. I can now just check my own handout here before I lie to you. See, I also sometimes get confused. That's why I give you these handouts, so that you can always double check, because it becomes confusing to remember these things. I don't need you to waste your brain power. Sorry, it's 10%. 10% of the issued shareholding. Section 189, well, let me answer this first, and then I'm going to get to section 189. So you need 2 or more shareholders that hold 10% of the issued shareholding. So and remember to tell me this. that they are two shareholders. You actually literally get a mark from this. George and Harry are two people. Then 10% of the issued shareholding. Now we've already calculated the issued shareholding. Actually made it easier for you by asking you that first question. So you need to calculate what do they need. So it's 10% of 11,250. What is that? $1,125. Now, do they meet that requirement? In order to check whether they meet that requirement, you need to calculate the value of both George and Harry respectively. George has got 5 Class C shares. Harry has got 5 Class A. Ten Class B and 10 Class C shares. We're talking in section 188 of issued shareholding. So the fact that George only has preference shares is not relevant for this particular question. Five Class C shares, so that gives us 5 times 200. Is 1,000. Five Class A shares is 5 times 10 is 50. Ten times 15 equals 150, and 10 okay, the way I'm typing it out here, it's actually, it doesn't matter quite how you set it out. Probably easier to do them underneath each other than in a row like that, but that doesn't matter. 10 times what are your preference shares worth? 200. Equals 2,000. So you're adding up your total here. We've got 1,000 plus 50 plus 150 plus 2,000 equals 3,200. Which is more than the 1,125 that they meet. So they have more than 10%. So they can call a meeting. We had a similar question in the first opportunity test. So this is just really a repetition of what you had there. I was quite shocked. Section 189. In the special test, there was a question similar, but can they call a meeting in terms of section 189, where suddenly just about everybody that wrote the special test just couldn't do this. One of the reasons why they suddenly could not do this is section 189 in the handout. Refers to 1/20th of the capital that carries voting rights. So in a question based on section 189, you will have to decide whether to include your preference shares or not. That depends on their dividends and the nature of the decision to be made. Section 189 refers to one or more, so you don't need two people. It can be a single person. Also need to refer to that. Don't just forget about that requirement. But what I found the most shocking is 1/20th. 1/20th equals 5%. People, you are accounting students. You should know that 1/20th is 5%. In the special test, the two shareholders that wanted to call a meeting each had 3% of the shareholding. 3 plus 3 gives you 6. You don't need a calculator to add 3 plus 3 and get to 6. And there were so many students that told me that they have 3% each, or 3% plus 3%, so they don't have 1/20th. It's 1/20th, it's not 20%. I was honestly quite shocked about that. Once again, I want to see these calculations in the exams. That is your motivation. Your motivation does not consist of copying section 188 from the handout into your test. Then the question would have read, please copy section 188 into your answer script. Okay, notice is given of a general meeting at which a special resolution is to be proposed that the directors should be removed from office. The meeting is attended by Annie, Dick, George, and Harry. Annie holds a proxy from Carol, who has instructed her to vote against the resolution. George holds a proxy from Edgar, who has instructed him to vote in favor of the resolution. Voting takes place by means of a poll. Annie and Dick vote against the resolution. Has the resolution been adopted? Motivate your answer. First of all, this is the question. In the case study, this question that they intend selling the fixed property, etc., etc., etc. That's just for background. The issue here is, what are they voting about? That the directors should be removed from office. So first of all, you need to decide Are you going to be including your preference shareholders in any of your calculations? Removal of directors. We've already seen that their dividends are fully paid up to date. Removing directors from office does not in any manner affect the class rights of the preference shareholders. Incidentally, if that was the topic, do they sell this fixed property or not? Because it's going to affect the value of their sales. That is also of their shares. The value of your shares is also not a class right. Your preference shareholders would similarly not have been included. Okay, so now you need to decide, has the resolution been adopted? When I gave you, when we did this unit, when we did all the different requirements for general meetings, meeting must be properly convened, properly constituted, and properly conducted. In this instance, we are only looking at the voting. I didn't give you any information about notices that were given. So that's not relevant. Don't say it hasn't been adopted because there was no proper notice. You don't know that. Don't make up your own facts. In order to adopt a special resolution, we need 3/4. This isn't part of your answer, just putting it up there. So that you know what we're looking at. So 3/4 of the voting rights present at the meeting, which means we have to calculate the voting rights at the meeting. That is your first step. What were the voting rights at the meeting? I copied and pasted the model answer there for you to save some time. You literally take those shareholders one at a time and do the maths. 100 plus 150 equals that, etc., etc. Working only with Class A and Class B. So George doesn't have any voting rights because he only has Class C shares. And you get your total. So we've got the voting rights present at the meeting. We need 3/4 of those. You need to calculate what is 3/4. I want to see all your calculations step by step. If I don't see all of that, if you've scribbled it at the top of your page or something and just tell me it's 1,125, you're not getting that mark. Also, start writing at the top of your page and carry on to the bottom. I don't want you squiggling little things there in the corner type of thing. It's like a balance sheet. It has a format. It starts at the top and carries on to the bottom. Not funny calculations in the margins. So they need 844. Now, then you have to calculate how many people voted in favor. In the case study, I've told you who voted against. Who voted against? What is their the total value of their voting rights? Remember your proxy. Remember your proxy. Annie holds a proxy from Carol. who has instructed her to vote against the resolution. So you need to include Annie. She has voting rights. You do your maths. Obviously, if those voted against, those that voted in favor is the difference, and your resolution has not been adopted. Want to see your calculations, people? Remember your proxies. Remember to take them into consideration. Last aspect I'm going to look at is contractual liability of a company. That is, obviously, there is a question on contractual liability of a company in the exam as well. I already told you when we did that part of the work that it will be in the exam. This particular model question that I have up here comes from the second opportunity, the makeup, not the second opportunity, the makeup test. Just did a copy and paste there to have a question to use. These facts aren't particularly important to this particular question. This was part of a longer question. I just copied them. Important bit here, also an extract from the question, is that all contracts entered into the company must be signed by at least 2 directors. Actual question that we're getting at is that Shingaite entered into a contract to purchase packaging material. I told you, that's why I copied this. It's a company that manufactures face cream from indigenous plants. I'll always give you the business of the company. So he buys packaging material. Omilongo, his fellow director, is not aware of this purchase. We've got Shingaite and Omilongo are the directors. All contracts must be entered into by a company, must be signed by at least 2 directors. Before we start looking at the answer, just the law. When will a company be bound? When will a company be bound to a contract? In the first instance, if there is actual authority, which can be either express or implied. Or a company can be bound to an unauthorized contract. If the contract is unauthorized, it must be in the scope of the business, and the representative somebody in that position, let's put it like this rather, somebody should normally have implied authority. But in this particular instance, they don't, because the contract is unauthorized. Now, to be perfectly honest with you, the answers that I got in the special test were absolutely horrendous, because just about everybody told me that Shingaete has implied authority. No, Shingaete does not have implied authority. He might be the managing director, but he did not have authority. He did not have authority because of what was stated in the articles, namely that all contracts must be signed by at least 2 directors. Umilongo did not co-sign. Because Umilongo did not co-sign, Shingaete was in fact unauthorized. If you tell me Shingaete had implied authority, you did not get the mark, because that is wrong. We did this when we did partnerships, people. So I don't understand why you don't understand it. If his authority was limited and he acted beyond the limits of his authority, he no longer has implied authority. The contract is unauthorized. So we are falling back on that bit. It's unauthorized. It is, however, in the scope of the business, packaging material. And as a managing director, he would normally, the managing director would normally, if it had not been for the provisions of this particular company's articles, a managing director would normally have been able to do this. And accordingly, the company is bound. I got some horrible things. Biggest mistake, students telling me that he had implied authority. No, he did not imply authority. Other students saying because he did not have Omilongo's signature, that the contract is not valid. That is absolute nonsense. There's no indication here that the contract is not valid. A director co-signing is not a requirement for the validity of a contract. You should know by now what the 5 requirements for a valid contract is. And having a co-director co-sign or having authority is not one of them. The contract isn't not valid. Contract is not binding. Those 2 concepts don't mean the same, people. And then I had lots of people telling me that the company is bound because the seller of the manufacturing of the packaging material did not know that he didn't have authority. That's got nothing to do with it. If he did know, the contract would not be binding because he would not be acting in good faith. But his lack of knowledge isn't what makes the contract binding. If this was a racehorse that he bought, the company would still not be bound, even if the third party did not know about this. And then very importantly, read your question. There were so many students who ended up telling me, but they can hold him personally liable. Got to make some more space here. I got this nonsense. And I can honestly only describe that as nonsense. The question is the company bound to the contract? The contract is not about what can they do against Shingaete or his behavior. That doesn't answer the question. Once again, if there's sub-questions, read all your questions before you start answering. And no, they cannot hold him personally liable. There is no provision in the law for them to hold him personally liable. At most, they can claim damages if they can prove that they suffered damages. But if they used all that packaging material in manufacturing and packaging their face creams, they didn't suffer any damages from him entering into this unauthorized contract. So what can they claim from him? You didn't think this through. Yes, he is, by entering into an unauthorized contract. He breached his fiduciary duty. There's a fiduciary duty for that a director must act within the limits of his authority. If this was bad quality packaging material that he bought and they couldn't use it, perhaps he also breached his duty of care and skill. But in both instances, that is not what I'm asking in this question. The question is, will the company be bound to this contract? And the answer is yes. Whatever recourse they have or don't have, or take or don't take against Shingaete, the end of the day is irrelevant to this question. Company has to pay the seller. They are bound to the contract. Okay, that's basically what I wanted to discuss with you. I see there's one random student that had actually joined the class that I was recording. Welcome, Hilalia. I hope you could hear me. Did I have sound? Could you hear me? She's not responding. Okay. Well, that was nearly an hour and a half. I hope this helps with the preparation for your exam. Good luck.